Hello, and welcome to today's monthly webinar. Before we begin, I'd like to note that this webinar is being recorded and all presentation materials will be posted on our website. If you would like to ask us a question, please use the Q&A, and if time allows, we'll jump into questions at the end of the session. Today we have Christopher Slotty with Schwab covering NHOs, ANCs, and tribes and federal contracting. Welcome.
Thank you very much. Yes, my name is Christopher Slotty. I'm with the law firm of Schwabe, Williamson, and Wyatt. I'm located in Anchorage, Alaska. And today we're going to be talking about Alaska Native Corporation tribes and Native Hawaiian organizations and their role in tribal federal contracting. And while my initial, when I was originally asked to present on this issue, we were going to focus on the constitutional basis for ANCs, tribes, and NHOs participation in federal contracting. However, given recent events with the SBA, including the SBA information request that went out to every single 8A program participant, I'm going to be taking a little bit lighter touch on that and focusing more on the regulatory and other issues facing 8A attendees, and specifically entity-owned 8A companies. So I think it is important to recognize that the SBA's 8A program and other small business contracting programs are congressionally established and mandated, and that the role of Native entities in those small business contracting programs, including their benefits and advantages, are also congressionally mandated through a variety of statutes, including the Small Business Act, the Alaska Native Claims Settlement Act, and various public laws. As you are certainly aware, right, to enter into the 8A program, an entity has to be owned by an entity must be a socially and economically disadvantaged small business concern, which means that it must be owned by a socially and economically disadvantaged individual, or in the case of a tribe or a Native Hawaiian organization, owned by an economically disadvantaged Indian tribe, economically disadvantaged Native Hawaiian organization. This means that by statute, ANCs, tribes, and Native Hawaiian organizations do not need to prove social disadvantage. They only need to prove economic disadvantage. And for Alaska Native corporations, they do not need to prove economic disadvantage because they are deemed under ANCSA as economically disadvantaged entities. So this is relevant because this means that Native-owned entities have an easier path to admission to the 8A program, and particularly, as we're going to discuss later on, much of the litigation that is focused on the 8A program is focused on a rebuttable presumption that applies to individual applicants to the 8A program, and this rebuttable presumption is addressing social disadvantage factor. And for Native-owned entities, you do not need to worry about establishing social disadvantage. That is not a requirement you need to prove to have access to the 8A program. So much of the current litigation involving the 8A program does not directly impact Native-owned participation in the 8A program, but it could have secondary impacts, as we'll get into later. As you're also aware, right, Native-owned entities have certain benefits under the 8A program, including the ability to receive higher sole source awards than individually owned 8A programs. This is also as a result of statute. This is a congressional mandate to the SBA, a congressional benefit afforded by Congress to Native-owned entities. It is not something that the SBA has adopted by regulation. It is a congressional statute, and that's specifically Public Law 100-656 and Section 823 of the 2019 NDAA. Another benefit that ANCs, tribes, and NHOs have under the 8A program is an exemption from affiliation for size purposes and the ability to have more than one 8A company. As is the case with Native-owned entities' ability to access the 8A program and their advantages in terms of sole source and direct awards, these two exemptions are congressionally mandated. They are portions of the Small Business Act. They are statutory. They are not regulatory. So what does this mean? This means that the role of Native entities in the 8A program and the benefits afforded them are congressionally mandated, and so therefore they can only be taken away or changed by Congress, not by the SBA or the current administration. And notably, Congress has the statutory authority to grant these benefits to Native-owned entities. Particularly Article 1, Section 8 of the U.S. Constitution states that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This is the Indian Commerce Clause and is the foundational constitutional authority given to Congress to mandate commerce with Indian tribes, including the provision of benefits under federal contracting programs. This is because the Indian Commerce Clause generally vests plenary powers, so kind of almost unlimited powers, over Indian affairs to Congress, and affirms that Congress when it's treating with native-owned entities, it is doing something based on a political rather than a racial classification. We would note that this Indian Commerce Clause and the fact that it treats status as a native-owned entity as a political classification as opposed to a racial one is critical and foundational, because if it was anything else, if it was a racial classification, it would be inconsistent with other portions of the Constitution, including such as the Due Process Clause. Therefore, as a foundational matter, when Congress is dealing with native-owned entities, including the provision of benefits under the 8A program to them, it is exercising its constitutional power under the Indian Commerce Clause, and doing so as on the context of a political relationship with Alaska Natives and Native Americans and Native Hawaiians, and not on a racial classification. And we have seen this throughout U.S. Supreme Court case law. In 2023, the Supreme Court recognized that while ANCs are not governments, they have been designated as tribes for purposes of federal laws, and that, and indeed in ANCSA, under 43 U.S.C. 1626E4, Congress specifically affirmed that its federal procurement programs for tribes and Alaska Native corporations are enacted pursuant to its authority under Article 1, Section 8 of the United States Constitution, i.e. the Indian Commerce Clause. So Congress is clearly exercising its constitutional authority when providing benefits to native-owned entities within the 8A program. And as I noted before, by providing these benefits, it is doing so based on a political classification and not racial. And this is comes from a 1974 U.S. Supreme Court case, Morton versus Moncari, which recognized that when the federal government is interacting with Indians, with Native Americans, with Indians, with Native Hawaiians, when it is providing benefits to them, it is doing so because of their political classification as a Native American, as an Alaska Native, as a Native Hawaiian, and not in any type of racial context. And that is important because under the U.S. Constitution, if Congress wants to provide benefits to certain classes based on their race, it is subject to a higher standard, it's called strict scrutiny, and it's very hard to establish that that racial classification or that benefit based on race would be permissible, would be constitutional. However, when Congress is acting on the basis of a political classification, such as it is when it's dealing with Alaska Natives, Native Americans, and Native Hawaiians, the standard review is only rational basis, which is a much lower and easier standard review to overcome. And then the final constitutional aspect of the benefits that Congress provides to native-owned entities is the federal government's trust responsibility to tribes and Alaska Native corporations and Native Hawaiian organizations. The United States Supreme Court has recognized that the United States owes a moral and a legally enforceable fiduciary obligation to protect tribal treaty rights, lands, assets, and resources, as well as a duty to carry out mandates of federal law with respect to American Indian and Alaska Native tribes and villages. This arises both from treaties, agreements, federal statutes, and court decisions, and indeed and it includes Alaska Native corporations as a result of ANCSA and the obligations and commitments made by Congress in ANCSA. So this means that the U.S. has a fiduciary obligation to protect the interests of ANCs, tribes, and NHOs, and provide for the overall well-being of Alaska Natives and Native Americans. And it provides another kind of foundational component for Congress's constitutional ability to provide these benefits in the 8A program to Native-owned entities. And then finally, I would like to note, as I mentioned before, the provision of these benefits to Native-owned entities is based on a political classification recognized both recognized in the Constitution and United States Supreme Court. It is not a racial advantage or a racial classification. Therefore, Native corporation contracting advantages are not DEI. They are an exercise of Congress's authority under the Indian Commerce Clause, and it is the fulfillment of Congress's trust responsibilities to Alaska Natives, Native Americans, and Native Hawaiians through the federal entities that Congress mandated: Alaska Native corporations, tribes, and Native Hawaiian organizations. So the bottom line is federal Native-owned entities' participation in the 8A program and the benefits afforded to Native-owned entities in the 8A program has a very strong constitutional basis and has a very strong legal foundation. And I am confident that Alaska Native corporations, Native Hawaiian organizations, and federal tribes should be able to, from a legal perspective, push back and properly respond and defeat legal challenges to their participation in the 8A program. However, while there is a strong constitutional basis for Native-owned entities' participation in the 8A program, we are certainly seeing significant impacts from the administration's different approach to the 8A program, including regulatory changes both specific to the 8A program and also generally in regarding to federal contracting. So we're going to first talk about the rewrite of the FARs. As you all know, the federal government went through a massive rewrite of the federal acquisition regulations. The focus of the rewrite was on basically reducing word count and relocating significant portions of the guidance currently contained in the FARs to kind of guidance documents located outside the FARs, specifically practitioner albums, the FAR companion guide, and a category buying guide. As a result of this, as a result of this rewrite, we have seen significant revisions to various parts of the FARs, including removal of cross-references to the 8A program, Hub Zone, and other SBA programs. We've also seen significant changes that emphasize giving contracting officers the discretion to make set-aside contracts for small businesses and 8A programs, and also an emphasis on competition rather than direct awards. I would note that FAR Part 19 contained the Rule of Two, which was the regulatory provision that required the federal government to set aside certain contracting opportunities for small businesses if there were two or more small businesses that were able to perform the work for a fair price. Because the Rule of Two, although it's been in place for over 40 years, was not statutorily mandated, there was a significant concern that the administration would remove the Rule of Two from the FARs as it went through this FAR rewrite. Thankfully, the revision of FAR Part 19 retained the Rule of Two, so it remains within the FARs. However, the changes they did make was to emphasize competition in the award of 8A contracts, essentially de-emphasize the use of direct and sole source awards, while also reducing the visibility of the 8A program and the use of market research to identify small business contractors. Additionally, the FAR rewrite continues an emphasis of this new administration on the use of GSA schedules and other multiple award contracts. And that is notable because the Rule of Two does not apply to task order awards under GSA schedules or multiple award contracts or blanket purchase agreements. And as a result of that, we could definitely see a potential reduction in the impact and applicability of the Rule of Two. And again, I think the FAR revisions, which emphasize competition within the 8A program and de-emphasize the use of direct or sole source awards, could presage a potential reduction in the use of those directed awards. There remain a variety of lawsuits involving the 8A program. One that I'm sure as everybody is aware of is Ultima Services Corp. Versus U.S. Department of Agriculture. This was the lawsuit that successfully challenged as unconstitutional SBA use of the rebuttable presumption of social disadvantage for certain individuals to apply for entry into the 8A program. As I noted before, right, ANCs, tribes, and Alaska Native corporations, and Native Hawaiian organizations, you do not have to prove social disadvantage to enter the 8A program under the Small Business Act. As such, Ultima Services Corp. Did not have any direct impact on entity-owned 8A companies or entities who are entity-owned companies trying to get into the 8A program. However, after obtaining the court order barring the use of the rebuttable presumption of social disadvantage, Ultima asked the district court as a remedy for what they've called past discrimination to issue an injunction barring the government from using the 8A program to award contracts in 3 different NAICS codes: 541611, which is Administrative Management and General Management Consulting Services, 561110, Office Administrative Services, and 561320, Temporary Health Services. If Ultima's request is granted, the federal government would be prohibited from awarding any 8A contract, sole source or otherwise, to any 8A company, individually or entity owned, that has any one of those 3 NAICS codes, which obviously could have a significant impact on some entity-owned business plans who are operating in those fields. Notably, this motion was filed on September 15th, 2023, and we have yet to see a decision from the court on it. We are continuing to monitor it, and we will certainly update everybody when and if a decision comes out on that motion. Another case is not directly impacting the 8A program, but is relevant, I think, because it suggests a potential strategy for the current Department of Justice. In Mid-America Milling Company versus U.S. Department of Transportation, several contractors challenged the DOT's use of a rebuttable presumption of social disadvantage in the DOT's DBE program. And just as what happened in Ultima, the federal court found that use of that rebuttable presumption, which applied to only certain races, was unconstitutional and enjoined its use. What I think is notable about Mid-America is that after that decision, which was done, so this lawsuit was started during the Biden administration, and then was concluded during the Trump administration. But after the Trump administration took over the litigation, they came to an agreement with the plaintiff and proposed a consent order to the federal court that would have effectively done away with the DBE program until the DOT decertified every single DBE and then recertified them without using the rebuttable presumption. What is notable about this is that the DOT's DBE program is congressionally mandated. So this is an example of the DOJ kind of going to the plaintiff and potentially trying to affect a legislative change through a court order declaring a congressional program unconstitutional, where it could not get Congress to change the program itself. So this is a kind of a strategy or potential risk that we will have to monitor for future lawsuits involving the 8A program. Will the current Department of Justice attempt to use these lawsuits to propose either quote unquote friendly settlements that have the impact of changing or eliminating the 8A program or other small business programs on the argument that they incorporate race-conscious programs and therefore unconstitutional, and therefore affecting a change to the 8A program that the administration could not get through Congress. So again, Mid-America Maryland Company does not directly impact the 8A program, but I think is potentially indicative of a risk that Native-owned entities may face in other lawsuits involving the 8A program, and caution that Native-owned entities really should be aware of and be tracking every lawsuit involving the 8A program, because there may be a need to intervene to defend your role in the 8A program if the current administration is not going to vigorously defend it. And then the most recent case is Marty Heyerholzer versus SBA. This was a lawsuit filed by against the SBA in the Eastern District of Virginia. It was also challenging the rebuttable presumption of social disadvantage in the SBA's 8A regulations. These are the same ones challenged in Ultima. What's notable about this is that the case was dismissed at the district court level and also at the Fourth Circuit because the plaintiff did not allege in his complaint that he was economically disadvantaged. Plaintiff was alleging that he was denied admission to the 8A program based on a failure to establish his social disadvantage, and that the rebuttable presumption was unconstitutional, and that harmed him. And both the district court and the Fourth Circuit said, well, regardless of your allegations regarding the unconstitutional nature of the rebuttable presumption, he did not allege in his complaint that he was economically disadvantaged, which is a separate requirement to have admission to the 8A program. Therefore, he had not alleged that he was otherwise eligible for admission to be admitted to the 8A program, and dismissed his complaint on standing grounds. The plaintiff has now filed a petition for writ of certiorari to the United States Supreme Court, asking the U.S. Supreme Court to take this matter up to address this standing issue. Notably, the SBA would initially decline to respond to the petition. However, the Supreme Court then asked them to respond. The SBA has filed its response to the petition, and it is opposing the Supreme Court taking up the petition, arguing that the lower courts properly addressed the standing issue. The administration's response did not include any attack on the 8A program, was focused solely on standing. And indeed, the issue on appeal is standing and not the validity of the 8A program. There's no mention of Native-owned entities in any of the briefing, so that's a good sign. However, we're going to continue to monitor this, because anytime anything involving the 8A program is potentially going up in front of this Supreme Court, we certainly want to be aware of it and closely monitor it to see, do Native-owned entities need to file amicus? Is there a need to seek to otherwise participate in the appeal to ensure that there's no kind of potential negative impact on the 8A program or Native-owned entities' participation in that program? There is likely to be additional legal challenges to the 8A program, including on areas that Native-owned entities may not be tracking, such as due process challenges to ICWA, which is the Indian Child Welfare Act, on which we have seen in the past have raised some challenges to arguing that challenges to the prior decisions that the provision of benefits or rights to natives is based on a political classification versus a racial classification, which is the foundational constitutional principle that supports Native-owned entity participation in the 8A program. So we're going to continue to monitor all lawsuits involving natives and this due process issues over racial classification, because they could have unfortunate impacts on the 8A program. And we're also trying to monitor a variety of lawsuits to determine, is the current DOJ going to basically lie down and not take action to defend certain programs or aspects of them? And if they do so, is it necessary for Native-owned entities to intervene to defend those programs that the current administration does not want to defend? And then we'll get to what I think is really what a lot of folks are probably very interested in, which is the current SBA actions. So I think it's important to recognize the SBA announced earlier in 2025 that it is reducing its staff by 43% while also taking on student loan administration. This will and has led to delays in processing applications, approvals, and other agency actions, and also reduces the ability of the SBA to advocate for its small business programs. We have seen a almost complete shutdown in the processing of entity-owned applications. In 2024, by my research, I believe 168 different entity-owned 8A applications were approved. In 2025, we've had 9, and none since, I think, August. And so this was even before the shutdown. So there's a massive backlog within the SBA, and we don't have a whole lot of visibility in how it's being managed, when it will be managed, or when 8A companies and native-owned 8A applications will start being approved. But I think that native-owned entities really need to be kind of cognizant of this issue and recognize that there might be very significant delays before your 8A application is approved. We also know that earlier this year, the SBA announced a full-scale audit of the 8A program. It was responding to a DOJ conviction of an individually owned 8A company for bribing a contracting officer to award them 8A contracts under the U.S. aid program. The SBA's stated intent was to focus on large contracts first, going back 15 years. And for a while, we did not see any response or any actual implementation of this audit by the SBA, but that has certainly changed recently. And we think the change is largely due to Senator Joni Ernst. She sent a very extensive document request to the SBA asking for a variety of different documents about the SBA's administration of the 8A program, including documents specifically about native and owned entity participation, such as the benefit reports that tribes, NHOs, and ANCs have to submit to the SBA. And then on November 12th, Senator Ernst sent these document requests to the administration and also sent a letter alleging that the 8A program provides unfair and inappropriate advantages to 8A participants and proposes that it states that it's going to be holding testimony on the 8A program. Unfortunately, it's one of those hearings is going to be held today, right at 11 o'clock a.m. Alaska time, 3 p.m. Eastern Standard Time. We will be monitoring that testimony and provide an update on what is said and what we think may come out of it. Potentially as a result of Senator Ernst's letters and certainly as a result of the SBA's prior announcement of its audit, on December 4th and 5th, the SBA began requesting extensive information from 8A entities with a deadline of January 5th, 2026. My understanding is that essentially every single 8A program entity has received this request, including those owned by individuals and those owned by natives, Alaska Native corporations, and tribes. So this SBA set a deadline of January 5th, 2026 to provide the requested information. And it is a very extensive list of information. I want to caution everybody on this call and any native-owned entity and every 8A participant, do not anticipate having an extension of time to be able to provide a response. We do not believe that will happen. Also, do not anticipate having any assistance from your BOS in responding to the audit. They are probably not going to respond to your request for assistance. They're going to require you to do it on your own and not provide any guidance or information or clarifications. So we really need to focus on getting the information in on time. My recommendation is if you can be a little bit produce maybe potentially more than you would otherwise technically be required, because we are very concerned that the SBA may be trying to use this as a pathway to kick people out of the 8A program when and if they do not comply. So start complying the requested data now. I would wait to see if there is further guidance published, although we're not optimistic that there will be some. You can request an extension, but don't rely on it. Plan to produce the information by January 5th. Recognize that there's a new SBA system, right? My SBA, make sure that you have access to it because that's the portal you're going to have to use to submit the information. As you go through the documents to comply with the data request, generate 2 copies, one that is redacted and one that is unredacted, right? Redact the confidential and personal sensitive data. Flag if you have any any CUI or other information controlled by CMMC guidelines, you may need to redact that or otherwise flag that when your submission. And again, plan to submit all requested data by January 5th, 2026. What is the audit focusing on? Our belief is the audit is going to be focusing on compliance with limitations on subcontracting, compliance with mentor protege agreements, such as ensuring that the tribally owned or native owned entity receives 40% of the revenue from the joint venture, Benefits reporting for some entity-owned firms, excessive withdrawals, i.e. excessive payments to employee and staff by 8A companies, and any indications of fraud, bribery, or anti-kickback compliance issues. SBA stated that the data will be reviewed by AI, so we're not sure what the end result is going to be. When you're trying to identify what information to provide to the SBA, specifically in regards to subcontractors, our recommendation is use the definition of subcontract contained in the SBA's regulations. That's 13 CFR 125.1. Notably, that definition would include your 1099 independent contractors. So you really want to evaluate that, particularly in context of your limitations on subcontracting compliance. SBA has confirmed this request covers the last 3 fiscal years, so fiscal year 2022, fiscal year 2023, fiscal year 2024. And then finally, you may not be able to rely, while the request says that if you've already submitted information to the SBA as part of your annual report, you do not need to resubmit it. Our belief is you cannot necessarily rely on information that you have submitted using the legacy certified.gov platform that may or may not be available to, you may or may not be able to rely on your submission of that information. And so to avoid any risk and to avoid giving the SBA any opportunity to graduate or force anybody out from the 8A program, we would recommend that if you had submitted information through the legacy platform, to resubmit it through the new platform to ensure, again, that there's no issue or question that you comply. So we have 4 minutes left, and I know we've got some questions. So while I have further slides to go through, I'm going to stop at this point and go to the Q&A and try to answer them as we go through them. So looking at the Q&A, so one, do you think the letter sent out by Senator Ernst this week will have any short or long-term effects on the 8A program and sole source awards? I don't think they will have an impact legislatively because I do not think that there are the votes to get through any legislative changes, but I think we've already seen that they might have an impact from the administration side, or either the administration continuing to slow down the approval of entity-owned 8A applications, or a continued focus of the administration on reduction in the use of 8A sole source awards. Another question was, Senator Ernst's letters to Congress seem to have some significant flaws that shows your lack of understanding about the 8A program, such as joint ventures, and similarly situated entities. How is the SBA or NACA pushing back on these issues? I agree. I think that is entirely true. I think there are very significant flaws in her letters, and she misses, or staff missed, certain specific SBA regulatory provisions that a lot of the native-owned entities that were called out in her letters are in full compliance. While I do not believe the SBA is going to push back on these issues, I think that NACA and others certainly are, and I believe that those entities specifically named in those letters are probably preparing their responses as well. It says it reads as though they want all vendors, not just 8A contract vendors. Is that interpretations? I agree that the SBA audit request is very poorly drafted and it is vague. I think the rationale, logically, it should be limited to vendors working on your 8A contracts because everything is kind of framed in the context of 8A contracts. So I would certainly provide all of those. If it's easy to provide all the vendors and you can segregate them and identify them as these are all vendors, not just 8A vendors, I think you would maybe consider doing that, again, to eliminate any risk that you may be removed from the program because of a failure to comply. In regards to the umbrella question, the concerns of the Congress's ability to provide federal contracting benefits to native-owned entities, yes, that applies to any SBA program, including HUBZone, et cetera. And I got 1 minute left, so I'm looking for other questions. Yes, the slide deck will be shared. The recording will be available. There's a question, do we recommend providing joint venture contracts? No, I think that the joint venture contract itself, so the contract between the joint venture and the federal government, that is actually not covered, right? It's asking for the 8A contracts by the firms. And then the final question is about item 9, copy of all 8A contracts on which the firm is currently working for the last 3 fiscal years is a bit confusing since it says currently working and over the last 3 fiscal years at the same time. I totally agree. There's a temporal inconsistency there. I think a rational review of that is any 8A contract awarded in the last 3 years or any 8A contract awarded in the last 3 years that you are performing. And it's kind of to what extent do you want to try to narrowly construe the request versus broadly construe it? If it's easy to provide all the contracts, that may be inappropriate, again, to avoid any issues. But I think you can rationally review that as any 8A contract awarded in the last 3 years that the company is currently performing. But again, we're hopeful to get more guidance from the SBA. There's no guarantee that interpretation is correct. And then I guess I'm going to go 1 minute over because I want to throw up this last slide as to what can 8A entities do. I think the focus that 8A entities should really focus on, or native-owned entities, is on the benefits of the 8A program to Congress, to the federal government, specifically in regards to the efficiency that it can provide to the federal government. You could also highlight local hire and community benefits. Native-owned 8A companies have operations throughout the country, and in many delegations other than Alaska, other than your local delegations, and you want to emphasize the benefit the employees you have in every single congressional district. It is also calling out that the 8A program is not DEI or based on racial classifications. You want to identify and emphasize the speed and efficiency of the 8A program, the cost savings, the fair price requirement. You want to review your compliance with 8A and small business program regulations. Do an internal review, generally with legal counsel, so you can apply the attorney-client privilege, particularly focusing on limitations of subcontracting. Beware of affiliate issues because the SBA is starting to focus on entity-owned family of company affiliate concerns, and also focus on the benefits you provide to your shareholders, your tribal members, your Native Hawaiian communities, because we do believe the SBA is maybe re-engaging on that and wanting to make sure and potentially examine how many benefits are actually flowing to the tribal members, shareholders, Native Hawaiians. And that is my time. I thank everybody very much for this 30 minutes. I know I was speaking very fast, and I apologize for that. I was trying to get through quite a bit of information. The slide deck will be available to everybody. If you have individual questions, please do not hesitate to reach out to me as well.
Awesome. Thank you, Christopher, for such an insightful and formative conversation. As a reminder, registration for the 2026 National Small Business Conference is now open. The 2026 event will be taking place on January 26th to the 28th at the Gaylord Opryland Hotel in Nashville. We do expect to sell out, so if you're interested in attending, please be sure to register as soon as possible. For more information, you can visit our conference website at n8sbc.org. As a reminder, this webinar recording and presentation will be posted on our website along with all of our other past webinars by the end of the day. Thank you all again for joining us today. This does conclude today's webinar, and we hope you join us for our next webinar. Thank you and have a great day.